Mr. Chairman, with a bold statement like that, I think you ought to let Mike respond. I don't think that's fair.
It's just not accurate. In no respect, you have defamed them. You have accused them of committing a crime here. That is a crime to testify falsely under oath. They did not do that. I challenge you to find one statement that you could defend as knowingly false made by them, as perjurious. That's what you've done. That's not appropriate.
I said they selectively misled. I didn't say whatever you just said, feloniously.
From an ethical standpoint, that has the same effect, and they did not do that.
With that, it is interesting when you've experienced many of these hearings, the nature of the questions that are asked. Some of the questions challenge the individuals on the panel because they ask them for personal views on issues, and many are instructed by the canons not to share personal views, but to try to stick with the law and not to prejudice any pending case or any future case. And so it puts many of the nominees in a tough position. We all have opinions on things, but judges do their best to suppress those and follow the law and facts in the case, which they're asked to do. So it creates a challenge in that regard.
Mr. Chairman, may I be heard on that?
When I finish, please.
Sure.
And I also want to say that many people have jobs to do that are created by statute and by law. For instance, to represent certain clients, Solicitor General would be representing, in some cases, the views of a mayor that are expressed through policy and through ordinances and laws and the like. They may not be views that you personally share, but as a litigant, you have a responsibility to be loyal to your client, not to allow them to lie or to have anything they say that is misleading be part of the record, but to honor them and defend their position. One member of this panel said, and I think properly, as a litigator, you do not necessarily share the views of the people you represent. In fact, very often, having been a litigator myself, I would say that you may disagree quite strongly with the views of the people or the litigating positions, even of the people you represent, but it's your job to represent them effectively and fairly. That was the senator from Missouri, and I think he was right in the citation that I've just read to you. I could go through the panel and say that depending on the nominee, each of us has said something like that. You do your best for your client, even though you may not agree with their fundamental policy views. You have a responsibility to represent them effectively and professionally. Senator Kennedy.
Thank you, Mr. Chairman. I agree. I concur in part and dissent in part with our esteemed chairman. I think he's right. We're all attorneys. We've all had clients we didn't agree with. Hell, we've had clients we didn't like much. But you do your job as long as it's ethical. And I can't recall a time that I have really pressed a nominee on a position that nominee took on behalf of a client, if I thought it was in good faith. I disagree with our chairman that your personal beliefs don't matter. Those of you who I questioned today, I specifically asked you if you'd allow your personal beliefs to influence your decisions, and you said no, and that's as it should be. But if you don't have personal beliefs, and you're not qualified to serve on the federal bench, you're just not. If you don't have personal beliefs, you're not a critical thinker. If you don't have personal beliefs, you haven't examined the world. You've just been robotic, doing what somebody told you. I think your personal beliefs do matter. And I think you ought to be able to discuss with us things like race in society, things like when does life begin? These are things that we all grapple with as Americans, as human beings. We need to talk about when does equal protection of the law attach to a person? Does it attach in the womb? Should it attach in the womb? We need to talk about racial progress in America, what we've gotten right, what we've gotten wrong. America caught the disease of slavery, but we beat it back. We should be able to talk about that. I've never asked your opinions or a nominee's opinions about a case that was pending before them or that might be pending before them. But when you come before this body, at least this is one person's opinion, when you come before this body and you refuse to answer a question about your personal beliefs, people are going to assume what they want. And sometimes they're going to assume correctly, and sometimes they're going to assume incorrectly. But they're going to assume, and they're going to attribute that belief as your belief. So I think you're making a huge mistake. I understand I've served only with two presidents. White House counsel's offices do their job. They get you prepared. They give you the questions that have been asked in the past. I get all that, okay? But I just have to dissent from my chairman that your personal beliefs don't matter, because they do. They do a lot. And they tell us a lot about you. Thank you, Mr. Chairman.
Senator Kennedy, I respect you much and I count you as a friend, but you and I both know the experiences we've been through in this committee. Nominees, potential nominees, even for the highest court in the land, would not take a somewhat neutral position saying, as a judge, my personal views don't count. They instead give us obfuscation. We've seen it happen on both sides of the table. You would think an issue as fundamental and basic and as well known as the issue of abortion would be one that you could express yourself on, where you stand, what you feel. But many, including nominees for the Supreme Court, would tell us, oh, you're talking about established law and established precedent. Then along comes the Dobbs decision. You say, what is this all about? You know, this isn't what you promised was going to happen. It didn't come out that way. So I understand nominees are in a difficult position. They're trying to follow the canons as they understand them as nominees and as sitting judges. And they don't want to prejudice future cases or pending cases that they might sit on. So that's just part of this process that both sides will use to their advantage when possible. And I respect you. I think you're a person of value and principle, but we disagree on this.
Well, Mr. Chairman, if I could just respond though to that, and Dick, I appreciate that point of view. I think Supreme Court nominees are in somewhat of a different position because they're going to be making the ultimate law of the land. I think lower court nominees are not in the same position, and I just don't see what we gain by not being able to talk about what people believe. I mean, I would like to hear what thinking people believe about, for example, is sex a biological fact or a social construct? I mean, I assume all of you have thought about that and have an opinion. I would also point out, Mr. Chairman, this isn't a criticism, you're following past precedent, but each one of these individuals, if they're confirmed, are unelected. They're there for life. For life. And we're not allowed to talk about what they believe. And we're only given, again, this isn't a criticism, 5 minutes?
Well,
come on.
By that logic, if you apply it to the highest court in the land, how many of them have been in elective office?
Some haven't.
Most haven't.
But that's why we also have, well, Earl Warren was, but that's why we also,
You have to go back in history.
that's why we also devote days to a Supreme Court hearing.
Yes, instead of 5 minutes, we take 15.
As we should.
Yes.
With second and third rounds.
Well,
But anyway, Mr. Lee, my good friend, wants to say something.
I have to be in a place right now, so please.
I will be brief. I just want to respond to the point about Dobbs. I've heard some colleagues say this, sometimes in the context of this committee's work, sometimes in other contexts, that there's the suggestion made that because nominees came forward and acknowledged that Roe versus Wade was established precedent, that somehow locked them in, and that they had, under oath, somehow betrayed their obligation to testify truthfully under oath. For every hearing that I've been a part of, and I've been here for 4 Supreme Court confirmation proceedings, not one of those justices who's been complained about, in the wake of the Dobbs decision, said that Roe or any other case was unassailable on any grounds ever, or was somehow protected under the doctrine of stare decisis from the possibility that future courts would conclude, as the court did conclude in Dobbs, that Roe versus Wade was without textual foundation in the Constitution, that it was without the kind of foundation that could make it a part of the constitutional analysis, not rooted in our nation's history, tradition, and so forth, as a matter of due process. I take issue with the suggestion that any one of these nominees misrepresented in any way, shape, or form their views on the Dobbs case. They could not answer further questions about whether it was assailable under a challenge, and they made no representations as to how it might fare under the doctrine of stare decisis. Such questions, when asked, are questions that they're understandably not allowed to answer under the canons of judicial ethics. Thank you.
So as chairman, I'm going to you take the last word. The people who were appointed to the Supreme Court by the Trump administration were pre-cleared for one purpose, to overrule Roe versus Wade. The Federalist Society, which was the secret handshake for every nominee who came before us from the Trump administration, was established for that purpose. We know that. regardless of the questions answered here in the Judiciary Committee, we knew what they were aiming for, and they finally reached that goal with the enactment of the Dobbs decision. But if you listen to their testimony before this committee, they carefully misled us or obfuscated the situation. You may disagree with me, but that's my opinion. I look at it and I thought to myself, I know where this nominee stands, and I'm not going to name names based on their life experience and where I've seen them rule or speak in the past. That's just the nature of this process. As I said, I get the last word because I'm chairman, so thank you. We'll carry on this discussion, I'm sure, beyond today. Thanks again to the nominees, their family, and friends.
Well, Mr. Chairman, with a bold statement like that, I think you ought to let Mike respond. I don't think that's fair. That's
It's just not accurate. In
That's a pretty
no
bold
respect, you
statement.
have defamed them. You've accused them of committing a crime here. That is a crime to testify falsely under oath. They did not do that. I challenge you to find one statement that you could defend as knowingly false made by them, as perjurious. That's what you've done. That's not
I said they
appropriate.
selectively misled. I didn't say whatever you just said, feloniously,
From an ethical standpoint, that has the same effect, and they did not do that.
without describing one another as defamatory. This meeting stands adjourned.
And that's how it ended, not with a gavel's tidy click, but with an accusation hanging, electric, in the air. Senator Mike Lee leaning in, voice sharpened. "You have defamed them. You have accused them of a crime, perjury." The room bristled. Chairman Durbin pushed back. "Selectively misled," he said. "Not the felony you just named, but a moral breach nonetheless." Seconds earlier, he had asserted, calmly but unmistakably, that nominees from the Trump era were pre-cleared to end Roe v. Wade, their testimony in this very room, a choreography of obfuscation. And before that, Senator John Kennedy had driven his own spike into the floorboards. Personal beliefs do matter, he argued, and if you don't have personal beliefs, you're not qualified to serve on the federal bench. In one hearing, the three threads of American judicial politics, ethics, candor, and ideology, twisted into a rope and began to pull in opposite directions. Let's rewind the fuse that led to this detonation. Durbin, sounding a practiced warning from years of confirmations, noted how nominees, bound by canons, wary of prejudicing cases, often dodge the deepest questions. He invoked abortion, the case law everyone knows, and the moment, along comes the Dobbs decision, as if to say, we were told one thing, and history delivered another. Kennedy answered with his courtroom cadence, half concurring, half dissenting. He agreed that advocates must defend clients they may not even like, but he refused the premise that personal beliefs are irrelevant. A judge without convictions, he said, is not a critical thinker. A judge unwilling to speak about first principles leaves the public to invent those principles for them. He wanted, he said, to hear where nominees stand on race, on when life begins, on whether sex is a biological fact or a social construct. If you won't say what you believe, the country will make it up for you, and then judge you by the invention. Durbin returned with the institutional memory of every hedged answer he's heard. He reminded the room that nominees can and do speak in the safe language of established precedent, only to be part of decisions that refuse to treat precedent as a locked door. Supreme Court nominees, he implied, play a different game than lower court nominees. Their silence has a higher cost. But Kennedy pressed again. These are lifetime appointments. If we cannot ask who a person really is, if we cannot test the bedrock beneath the robe, what exactly are we doing? Then Senator Lee stepped forward, the third act overture. He rejected the narrative that those justices ever promised Roe was unassailable. They called it precedent, yes, but never unchallengeable. The claim that they misled under oath, he said, is wrong, and to say otherwise edges toward accusing them of lying to Congress. Find one statement, he challenged. One statement, Knowingly false. The hearing's temperature spiked. Durbin kept the chair's prerogative, insisting on his reading of events, the pre-clearance pipeline, the guiding hand of the Federalist Society, the inevitability written into nomination politics. Lee's charge, defamation, criminal innuendo, struck back like a recoil. The chairman, asserting the last word, tried to narrow it. Selectively misled, he said, ethically objectionable, but not the felony Lee named. The gavel finally landed. This meeting stands adjourned. What does this reveal about government, justice, and the American experiment at this hour? That we are no longer arguing merely about outcomes, we are arguing about the legitimacy of how we arrive at them. One camp insists that judicial nominees mask intention behind sterile phrases, securing power with public neutrality while pursuing private aims. The other insists that demanding ideological confessionals would turn Article III courts into elected offices by another name, punishing fidelity to the canons and rewarding the loudest orthodoxy. Underneath both is a more elemental anxiety. Do institutions still deserve trust, or must trust be wrestled from them by exposure and confrontation? Kennedy's intervention pierced the technocratic ritual. He gave voice to a citizen's ache. Tell us who you are, or we will assume the worst. Durbin's reply captured the institutional defense. There are rules here, rules meant to protect impartial judging, and the record of those rules includes painful surprises. Lee's defense laid down a lawyer's line. Precedent is not promise, and disagreeing with Roe on constitutional grounds is not perjury. Together, the exchange exposed an American paradox. We want judges who are both human and machine. We want their beliefs to prove they are thinking, and their discipline to prove they are not ruled by those beliefs. We want candor without commitments, transparency without prejudgment, moral clarity without ideological capture. The hearing showed how nearly impossible that balance has become in a nation where every answer is clipped, posted, and weaponized in minutes. But the stakes are not abstract. When a chairman says nominees carefully misled, he is not just rewriting a hearing transcript, he is chiseling at the court's authority in public memory. When a senator answers that such a claim approaches perjury, he is not just defending a nominee, he is defending the line between skepticism and delegitimization. And when another senator demands personal creed from future judges, he is not just looking for philosophy, he is testing whether an age of silence has become an age of cynicism. The camera pulls back. The dais empties. Staffers collect papers. Yet the question remains, dense and unresolved. What is the honest way to vet power in a republic that fears both pre-commitment and secret agendas? What does honesty look like when neutrality itself is under suspicion? If we cannot answer that, we will keep replaying this scene, the demand for beliefs, the invocation of canons, the accusation of misleading, the counter-accusation of defamation, until the public concludes that all of it is theater and withdraws faith from the stage and the script alike. The moral is as cold as it is urgent. Democratic legitimacy is not just about the law, it is about the perceived honesty of those who interpret it. If we hollow that out, by silence that feels evasive, or by rhetoric that treats disagreement as deceit, we will inherit a judiciary that commands power but cannot command belief. The Constitution can survive many storms. It cannot survive the death of trust. This has been Congress' signal. If you believe sunlight strengthens institutions, not destroys them, stand with us. Subscribe to Congress Signal. Support our work to expose the truth.